Good afternoon, everybody. I'm just pausing so that we can get everybody in. I see that we've passed the magic 200 number, so I am going to stop. No one wants to be here beyond quarter to six, 6 o'clock. I'm Tina Cook. I'm a member of the family team at 42 Bedford Row. I have with me today Charmaine Clubb, who is a rising star of the family bar. She was called in 2020, but she performs well in advance of her call. We are going to be talking to you today, really by way of an interview between the two of us about finding of fact hearings in the remote era and beyond. It's a combination of recent authorities and not really practice directions, guidance from the president, a bit of research. We're going to talk to you, we're going to talk between ourselves for 20-25 minutes, and then we're going to have 10 to 15 minutes of questions and answers. If you could ask your questions on the question and answer button, we can see those and we can respond to those. I must say we already have a couple of questions that people have sent in who can't come. So we've already got 2 or 3 questions, which we'll go to in any event if nobody else has any questions, but we'll just pick a few. We're aiming to finish at about 5:45 because we know your time is precious. I'm quite sure you've only just signed up because you know it's going to be a short shot, but here we go. So Charmaine's going to kick off with a few questions and I'm going to answer, and we're going to bat it between the two of us.
Thank you, Tina. So first of all, do you think remote fact-finding hearings are fit for purpose?
Well, I have been, as I'm sure lots of us have, involved in fact-finding hearings from the very beginning of COVID. And my view has really, really changed over time. I can't tell you how at the beginning, I was incredibly cynical about it. And I thought, oh my golly, this isn't going to work. How on earth can this be fair? It's sort of that delicious interplay between fairness, transparency, depending on whether you have a vulnerable witness, a vulnerable client or witness, which we always do in these cases. And I started off thinking that this just simply can't work. And what on earth are we thinking? And of all the Court of Appeal cases, they're going to be saying, you can't do this. And within weeks, it became very clear to me that it does work. It has worked. Okay, there are some cases it doesn't work, but I think they have been. And I think the evolution has been pretty amazing. I think the family bar, the family solicitors, the family lawyers have done a fantastic job of keeping the show on the road, because if it hadn't been kept on the road, I think it would have been an utter disaster. I think there are some glitches, but basically, the evolution is something I've been pretty impressed by, and how we've all worked exhaustively to make it work, judges, barristers, solicitors, and clients. So I think broadly, I think yes. What do you think, Charmaine?
Yes, I'd have to agree with that. I think the attitude of many family practitioners, it seems to me, has really transformed from thinking this would be impossible to, well, why not? And I think with the fact-finding hearings I've seen, they've certainly worked very well on CVP. I think coordination of witnesses has been very efficient, and you certainly have a clear view of a witness's face and facial expressions while they're giving their oral evidence. And I think, of course, in the early days of the pandemic, having recourse to remote means avoided lengthy delays, which we know is prejudicial to the welfare of a child. So certainly I think they can be and often are fit for purpose, but I suppose I would caution against choosing convenience over fairness. And I suppose there are certain features of fact-finding hearings that perhaps make them slightly less well suited to being heard remotely. So, for example, there's generally much more evidence to navigate, sometimes across several different e-bundles with videos and audio recordings and the like. And I think from a practical perspective, that can be quite challenging for a client or a witness to manage remotely, and that can cause delays. So I think there are hiccups, but overall, I agree that they are largely fit for purpose.
It's interesting, isn't it? Because I've certainly had judges when I've said, or I've been in courts where somebody said, well, Judge, how on earth can you assess the credibility of that person online. How can you do that? And I've heard really differing views from judges. At the beginning in particular, people would say, ridiculous, I couldn't possibly, it's a postage stamp size, I simply can't, I need to have them in court, I need to see everything. And I think there's been a gradual change in that too. Well, actually, when I have that person on the big screen because they're talking and therefore they show up really well, I get quite a lot more or different things from them than I would if I had them in court. I'm still firmly of the view that it's not just what happens in court, it's the whole body language in court, outside court. And I'm forever saying to my clients, look, be really careful, because whilst you're outside court, the usher is going to be listening to you. And if you're kicking off, if you're smiling, if you're laughing, that will get back to the judge. It's all about that experience and tactics. You just keep quiet and do the right thing. And that, I think, is lost. And perhaps that's a good thing. Perhaps the tittle tattle of the usher going back to the judge is actually a good thing, because we don't get that. Of course, then of course you get the position where someone forgets to turn their camera off and you hear, or their mute on and you hear all sorts of things, or their camera off and you see all sorts of things. But I think that's good. That's right. And I think the research does show, I mean, I was going to refer to you later on, but there's certainly some Oxford University research, the Faculty of Law. And I should have said at the beginning, not only is this being recorded and will be on the YouTube, the 42 Bedford Row YouTube, but we will send to you a list of the authorities and the research we refer to. And on my list, certainly, is a piece of research by the Oxford University Faculty of Law called Virtual Justice, Enhancing Accessibility, Participation and Procedural Justice in Family Courts and Tribunals. And they were really concerned about, I mean, let me read some quotes from that because it's really quite important. It was October, so we've moved on. They were concerned about the lay client being really emancipated in their participation, that the vulnerable were the most affected. Those people who were drug and alcohol users, neurodiverse, homeless, experienced abuse, simply couldn't access those things which Charmaine and I take for granted. And it was their research, which they worked actually with the MOJ. They worked very carefully with the MOJ to try and improve the packages, to try and improve the experience of the users, the lay clients. I mean, it must be appalling. I mean, I don't know what you think, Charmaine, but it must be appalling for a lay client who comes along to court, and it's almost trivialized by being on television. It's not a real, you know, if you take, for example, somebody who is at risk of having their child removed from them, it's absolutely appalling that they must think, you know, here's this bunch of barristers, solicitors, they come along, they seem to know each other, they say hello to each other online, call it Christian names and first name terms, and you know, what about me? And I think it really is beholden to us, as the Oxford University Faculty of Law said, to really work so much harder with our clients, to make sure we speak to them before, to make sure we speak to them during, to make sure we speak to them afterwards. Those things that if we were standing in court, we would have no choice but to do. But because we're not standing in court and because we can just disappear off and turn the camera off, I think it is a mixed bag, isn't it? It's really very difficult to get that balance right, I think.
Absolutely. And I think so much is lost in translation through the screen, and it is a much more sterile atmosphere. And as you say, us lawyers, I think, have to put in more effort with remote hearings to ensure that our clients don't feel unsupported and they understand fully what's going on, particularly when really serious allegations are being adjudicated upon and the like. So I think in general, it is important to be cognizant of certain factors that might make a remote fact find more challenging, or might militate against proceeding remotely, whether that's lack of digital proficiency, additional needs or vulnerabilities of the parties, or so on. So I think it is important to remember those things.
And one of the things that certainly less research, more experience, is transparency. And one of the other research, or one of the other tools which is on our website, on our list, and I want to talk to you about, is the concerns that, of course, in family law, there's always been an issue about transparency. There has been, there always will be, because of the confidentiality. But in October 2021, Andrew McFarlane, the president of the Family Division, produced a report, Transparency in the Family Courts. And it just emphasizes, again, back to the point of the lay client, that, you know, justice taking place in private where the press can't report, it really limits the public information about what can happen. And during COVID, particularly at the beginning in remote hearings, and he makes the point, particularly in finding of facts, because the facts are all important. The finding of facts cases are so important. Perhaps we've strayed away a bit from that, Charmaine, because one of the clear directions from all the courts I experience is it's all very well to have some hearings, remote and hybrid, but we really need to see people in the finding of fact, because usually they are so utterly important. They are very much credibility based. And the transparency Andrew McFarlane was saying back in October has really taken a knock with the reported judgments falling tremendously between 2015 and 2019. And then after 2019, because certainly for the first 12 months, no one had a clue what to do, how to access. And you'd have lovely Brian Farmer from the Press Association, who used to run around, that still does run around the RCJ and see us and know what he wants to report, not having the first idea how to get involved in those hearings. So Andrew McFarlane points out that the system has been suffering from serious reputational damage because of lack of transparency, and the remote hybrid hearings has only made that worse. So it's a perception, well, I think it's a reality in terms of the hybrid hearings, that everything is happening behind closed doors. So it's quite a long document, the Transparency in Family Courts document, and it does sound a bit OTOs to what we're saying, but there's a huge impact on what we are doing and what we are saying in terms of transparency. And also in terms of vulnerable witnesses. I think you're going to come to that, Charmaine, in the authorities, but it's certainly, as far as the research is concerned, both the Oxford research and the transparency research, is that those vulnerable people, and remember, almost everybody we deal with in these cases, in the public law cases particularly, almost everybody has a vulnerability one way or another, whether they're subject to domestic abuse, whether they have been in the care system themselves, whether they have a low IQ, whether they are impoverished financially, whether they have drink and alcohol and drugs problems, whether they have mental health problems. All those issues in terms of a finding of fact puts them at a disadvantage immediately. To have to navigate with the computer technology as well, the research is really very clear. In lots of respects, the remote hybrid world has taken that quite a long way further back. But let's turn to the authorities. Charmaine, in terms of the authorities, we know almost from moment one, and I know that because I was in some of the early ones in the Court of Appeal, almost from moment one, those brave judges, I'm thinking, for example, of Mr. Justice Williams, who said, we are going to get on with this. We are simply going to deal with this, like it or not. I remember being in a corridor in the RCJ and him saying, well, you're going to turn up, aren't you, Miss Cook? And I thought, well, yeah, I am. It's a bit scary, but I am. So tell us about the early authorities. What did the early authorities say, and how were the courts dealing with it right at the beginning of lockdown?
Yes, absolutely. Well, perhaps we could start with Re-C, given you've mentioned Mr. Justice Williams. That might be a good place to start. So in that case, there were underlying care proceedings concerning the death of a 3-year-old girl due to cocaine ingestion. And essentially, the appeal arose from a case management decision to continue an attended fact-finding hearing in circumstances where lead counsel for the mother was unable to physically attend court because she was shielding. So I think this case for me really illustrates the balancing of the competing rights between the parties. And in undertaking that balancing exercise, the trial judge concluded the inability of mother's counsel to physically attend would not prevent her from having a fair hearing, whereas counsel for the mother on appeal argued that the judge's decision prejudiced her client's right to participate effectively in the hearing and created effectively an unacceptable inequality of arms. And she argued that the judge allowed considerations of delay to dominate his evaluation of welfare and the Article 8 rights of the children, despite there being a wider welfare interest in the need for a just decision. Ultimately, the Court of Appeal held that the format proposed for the remainder of the hearing, with mother's lead counsel attending remotely, but junior counsel being physically present in court with the mother, did not breach the mother's right to a fair hearing. And I'm just going to read a couple of quotes from the judgment that really stood out to me. So the Court of Appeal at paragraph 24 says this: perfection in the arrangements for a complex trial of this kind is not always achievable, and the contemplated arrangements comfortably satisfy the requirements for a fair hearing. And they also held a difference in the way parties are represented does not of itself amount to an inequality of convention rights. And I think significantly, the Court of Appeal emphatically rejected the submission that the length of delay would be a small price to pay. And they said, time is running against these children, and 3 months or more in the lives of children of preschool age and a baby is highly significant. Tina, you were counsel for the intervener in this case. I'd be really interested to know what your views were on the ground.
Well, it was at the vanguard. It really was. And the case started, I think, I don't know, but about April 2020. And it was at that moment where we'd all been told that Zoom and Teams and things like that existed. And some of us, most of us, me, had never heard of them and thought they weren't going to work in a million years. And people in all various chambers and the FLBA were trying really hard to give us lessons in how these things might work. So it was a little bit scary, actually, Charmaine, because there we were. It was a little bit scary, but it was also, so to say it's quite funny is really making too light of it, I think, but it was such a new experience that we were all just doing our best, and everybody was being very patient with everybody else, particularly the judge, because things were going wrong. But in terms of the actual appeal, I think it was opposed by everybody except the party who made the application, who appealed, because I think on the ground it didn't appear unfair. We had a judge who was bending over backwards to make sure that if our camera went fuzzy or if our voice disappeared, we stopped. We had the time. No one was put under pressure. Everybody was given. I think it still happens. I'm glad to say it really does still happen in my experience, whether in the Court of Appeal or whether you're in whatever court you are. Everyone's very patient and allows you time, which is exactly how it should be. But we were learning. We were all learning together how to do it and how it should work. And I thought it was working very well. So when the appeal judges supported that, I was greatly relieved, because the children, as you just read out, were very young. And I can only congratulate the judges, all the judges in all the divisions and all the courts, for making this work, because it's an absolute miracle that it did work, because otherwise children would have been sitting around waiting for these decisions, which would have been appalling. So on the ground, yeah, I was pretty happy that it was, but it was working well. So how have the authorities evolved, Charmaine? Tell us about the more recent ones. There's some very, very recent ones, aren't there, I think?
Yes, of course. So there's a couple of recent ones that I'd like to talk about. Firstly, ReBB. So this is one of the 4 conjoined domestic abuse appeals from ReHN, which was remitted to the High Court for rehearing following the successful appeal. And for those of you who may not remember, the basis of the original appeal was that the judge had improperly made a consent order in circumstances where there were unresolved allegations of domestic abuse, including rape. So very serious allegations. At the fact-finding hearing in ReBB, Mr. Justice Clubb was tasked with determining the parties' cross allegations of domestic abuse. And just thinking firstly about mode of hearing, at the request of the parties, the fact find was conducted in a hybrid form. And given the serious allegations, Practice Direction 3AA in the Red Book was engaged. And so Mr. Justice Clubb had to think about what participation directions would be appropriate to essentially help the parties give their best evidence. So what happened at the fact find was the mother gave her evidence from the witness box in the courtroom, whilst the father participated remotely by video. And then when the father gave evidence from the witness box, the situation was reversed, with the mother participating remotely. And importantly, the parties couldn't see each other when giving their evidence, as the camera was turned to face counsel. So I think this setup really illustrates how creative use of remote technology alongside appropriate participation directions can really maximize the quality of the evidence given by the parties. And no doubt it would have been less distressing for the parties because they weren't face to face with one another in the courtroom. In terms of Mr. Justice Cobb's approach to the fact-finding exercise, he highlighted 7 aspects at paragraph 6 of the judgment. I'm not going to delve into every aspect, as I think that's probably outside the remit of this webinar, but I would like to briefly touch on the first one, which is this: the benefit of considering the evidence relevant to each different form of alleged domestic abuse in clusters, rather than by reference to freestanding items in a Scotch schedule. So originally, this fact find was set up with the parties filing respective Scotch schedules, but following re-HN, it was decided that, well, Mr. Justice Cobb essentially decided he'd deal with the allegations by subject headings. So for instance, control and coercion, physical abuse, financial control, sexual abuse. And that's clearly in keeping with the guidance given by the justices of the Court of Appeal. But I think it's very helpful to see the application of that guidance through Re-BB. And reading the judgment, it really struck me that the clustering approach helped Mr. Justice Cobb contextualize the narrative of the abuse and to gain a sort of overall impression of the parties' relationship. And that enabled him to adjudicate on the allegations through that more nuanced lens. So just one quick quote from the judgment, which stood out to me. He says, "The mother's description of the relationship is, to my mind, entirely recognizable as the behavior of someone caught up in the wall of abuse, who has lost any objective sense of what is acceptable and unacceptable in a relationship. I remind myself she had no experience against which to judge this relationship, and in all likelihood became codependent on her partner in an unhealthy way. I find that her self-esteem and sense of worth has been eroded to the point where she could not look beyond the relationship with the father. She became immunized to the emotional volatility of a relationship which she had become to believe was normal and acceptable. She simply sought to cling to what she knew." So yes, I think this judgment has lots of interesting things to say, not only about domestic abuse and the application of the guidance in Re-HN, but I think it also shows how far we've come in terms of remote and hybrid hearings and how we are much more confident about use of the technology, and we can marry that up with sensible consideration of special measures to really maximize the oral evidence in court. And no one really batted an eyelid about the hybrid proposal in Re-BB. So just moving on to another authority, KL&M, I'll just talk about this briefly. So this case concerned proceedings brought under the Hague Convention, whereby the mother appealed against findings made by the trial judge at the fact-finding hearing. And just by way of background, the mother met the father online whilst working as a cam girl, providing sexual services, and they commenced a short relationship and had a child. At the fact-finding hearing, the mother made allegations that the father had raped and sexually abused her, and that he was controlling, manipulative, and intimidating. So again, very serious allegations. The mode of hearing was very similar to that in Re-BB, where the mother attended in person with her interpreter and counsel, whilst father attended remotely, and then they swapped over. However, the difference here is that this proposal of alternating physical and remote attendance seemingly was only made to meet restrictions on the number of parties in the courtroom at that time because of COVID. And despite mother quite clearly being a vulnerable witness, there was no consideration of participation directions and there was no ground rules hearing. So unlike in Re BB, this trial judge didn't direct herself as to whether special measures or might be appropriate. So following the decision at first instance, the mother appealed on 2 grounds, but I'll just talk specifically about the vulnerability and special measures point. She argued that the judge's failure to treat her as a vulnerable witness and make special measures rendered the fact-finding hearing unfair. And mother's counsel pointed out that when mother gave evidence and the father joined remotely on that day, he spoke directly through the screen rather than through his counsel to point out he couldn't see the mother. And the judge told him he should be able to see her and that if he could not, he should raise his hand and it would be dealt with. And mother's counsel argued this had the effect of essentially alerting the mother right at the outset to the fact that the father was worried and concerned about watching her, and the judge would intervene if he wasn't able to. And I think what's clear is because there was no consideration of special measures and ground rules, it's very likely that the quality of mother's evidence was diminished. And the judge says at paragraph 66 that this is a case that cried out for participation directions and a ground rules hearing, not just for the mother, but also for the integrity of the process itself. And here the need for directions went beyond the need to consider whether parties shouldn't come into physical contact in the courtroom, and matters such as whether the mother should be shielded or not were highly relevant and should have been considered. So I think this is a very interesting case for vulnerable witnesses and special measures. And there's clearly a distinction that we can see in the treatment or the case management by the trial judge as compared with Re BB.
But it's interesting, isn't it? Because that case, the KLM case, was heard at first instance before the Domestic Abuse Act had been incorporated into the family procedure rules. So there's some of course, perhaps there isn't mitigation, but there's some mitigation for the first instance judge. It should have been obvious that somebody who had alleged or had possibly been subject to domestic violence, coercive control, ought to fall within that category of vulnerable person. It's sort of, I guess it's one of the benefits, one of the hidden benefits of remote hybrid, because inadvertently, the remote hybridness of that case allowed the lady in question to have special measures. I know that Mrs. Justice Judd found that that wasn't enough because it hadn't been proactively considered. But it's interesting that that the hidden benefits of that are really quite beneficial, quite good fun, quite interesting in terms of how cases proceed.
Yes, absolutely. So I think just pausing with the authorities for the time being, Tina, looking to the future, do you think remote fact-finding hearings are here to stay?
I don't really think remote fact-finding hearings are here to stay. I think it's funny because it's interesting, last Thursday, in fact, there was an announcement from the President of Family Division in respect of the High Court. And he said that from the 1st of March, the Family Division, any applications issued in the Family Division to be heard in the RCJ will be listed as attended hearings. So as from the 1st of March, unless you have a good reason, anything issued in the RCJ will be an attended first hearing. So that includes any proceedings which might lead to findings of fact or not. What he does make clear that there's a local level decision to be made at other court centres. So RCJ is one thing, and he's still allowing court centres, judges to make their own decisions in various different places. But any request to vary that, it will be attended, is to be made to particular judges. So particular judges are going to be allocated to hear that. So there's uniformity as to the decision making, and it will be based on the interest of justice. So the interest of justice to all the parties. And so far as findings of fact are concerned, I think the family division had the view very firmly set out, and it's produced on our note as well, which you'll see on the website, and we'll email everybody. It was the speech of Andrew McFarlane at the FLBA conference on the 16th of October, which has been transcribed and published. And he was very clear at that point that there weren't going to be diktats and there weren't going to be practice directions. It was really going to be a case-by-case basis. But he outlined the disadvantages of having remote and hybrid hearings. He said, for example, we seem to have come to a stage where experts almost invariably give their evidence remotely, but they always did. So actually, I think that's probably a good use of time. And he set out a number of types of cases which were right to hear remotely. So he said the important ones in public law hearings, which were going to be heard face-to-face, were likely to be the first CMH, the ICO hearings, the IRH, and the final hearing. The final hearing, whether or not that's a finding of fact. So those things, I think, are very clearly going to be face-to-face unless you have a good reason. So the vulnerability, the transparency issues are going to come into play. The fairness points are going to come into play. I don't think the convenience factor is going to wash very much anymore. Interestingly, immediately last week after Andrew McFarlane had said it's going to be attended hearings, there was a communication apparently from Mr. Justice Moore in relation to litigants or lawyers overseas. So I'm sitting in Madrid, where I've been for the last 6 months, and I'm going to conduct my practice from there, is no longer going to wash. So I think we are going to be compromised in terms of our social lives, because we are going to have to go to whichever court sends us. But I think that the benefits for that, as everybody knows, is one, it's lovely to see everybody, and our club can come back and we can see people we haven't seen for a very long time. And two, there are so many benefits for the junior bar, for the senior bar, for everybody to meet outside, to see how things work face to face, to get a feel for the courts, to have an opportunity before your hearing to negotiate, to settle the case, to come to some sensible compromises on contact or whatever it might be. That is pre-hearing discussions between the lawyers. It is all very well, but it's no substitute for sitting outside court, standing outside court, having a coffee with your opponent and hearing things that you wouldn't otherwise hear, for the benefit of the case and for the benefit of the lawyers. I think it's a good thing. So I don't think pure remote hearings, finding of fact, are going to endure much beyond the 1st of March. I think we all need to be realistic about that. I think there might be days within those hearings that we can have days where the experts are all called, so we can all be remote, because actually it's much more convenient for all of us and the experts. So I think that's really my view. What do you think, Charmaine? You've probably only known remote hearings.
Well, I was going to say, I think it'll be quite interesting for me going sort of back to the old ways, as it were, because I started pupillage during the pandemic. So this is sort of all I've ever known. And I think you're quite right. Things like pre-hearing discussions and negotiating and having a conference with your client would be much, much easier in person. And certainly for fact-finding hearings specifically, I mean, the Nuffield Family Justice Observatory has some quite interesting things to say about this. And it did, I think, last year, rapid consultation into remote hearings post-pandemic. And I think the tenor of the feedback was very much, there was continued support for remote administrative and submissions only hearings, but considerably less support for remote fact finds and contested final hearings. And I think that's right and not really very surprising. And I think there were specific concerns raised about, for example, litigants in person struggling to cross-examine in remote fact-finding hearings, and barriers to communication with one's own legal team, and so on and so forth. So yes, I think there will be a diminishing role for remote hearings as we go into the future. that will be a little sad for our social lives, as you say.
Our domestic social lives, yes. Our work social lives, probably not.
No, very true.
Come back case lunches and come back having a coffee with somebody, you know, before court. That's something we've all missed. Well, you haven't missed because you haven't known it, but I've missed. Like, we got time for a couple of questions. I promised we'd be away by 5:45. So I have got a question. I've got a question online from Norman Hartnell. Hi, Norman. So a Devon question, really. So Norman asked the question online, and he says, I've had a couple of cases where a remote litigant has been noted to look to a solicitor or even text for guidance. How can such be avoided? Norman, I'm not sure whether you're talking there about your own clients, but I think, Charmaine, I'll ask you in a moment what you think. I think it's a good and a bad thing that our clients can communicate with us that way. It's not a substitute for tapping us on the shoulder and asking us or moaning outside court. If it's not your client, I think it's back to that duty that we all have to look after somebody who needs some help. The other thing that occurs to me is, and I know Norman, I was in court remotely this morning in your neck of the woods in Exeter or Devon, I think, in front of a judge who we both know. And the warning has got a lot tighter. It seems to me. I had a very tight warning this morning from one of the lady judges on the Western Circuit, making it very clear to my client, who was the only person attending, that she mustn't do this and she mustn't do that and she mustn't do the other. And it was interesting. So I think there isn't much you can do about it. I think the chat room functions quite a good thing in terms of if something does go wrong or something isn't quite right, to say almost publicly, I'm being asked the question, does anyone have an objection to that, or does the court want to hear about that? So I think that's my view on that. Charmaine, do you have anything to add on that?
Yes, no, I think that's right. I mean, certainly when another witness is given evidence and my client wants to tell me something about it over WhatsApp, I find that very convenient, and I can just instantly see if they want me to ask another question or explore a point. So I find that very handy. But I think one thing to be very careful of, if you have a sort of group WhatsApp with different clients or different parties in, is to make sure that they always get removed from the group while they're giving their evidence. So
and Norman clarifies just now, it was in fact not his client, it was with somebody who was giving their evidence. And I think you know, to everybody, it's very easy and proper to say, when that happens, I simply can't talk to you, and judge, please would you give the witness the warning again that they can't do this, and just deal with it very openly and very formally. That's certainly it's all recorded, so you actually want it to be out there on the recording in case somebody says of you, the professional, later on, look, I asked this person, I just want it out there to protect ourselves. I've got another question. Must confess, can't recall who. I've got another one from Norman, but in between Norman's questions. What do I do if I'm unhappy with the decision about how a case is to be conducted in the hybrid remote world? Do you want to have a go at that, Charmaine, or shall I?
Well, I can start off. I suppose it sort of depends on what stage in the decision-making process you're at. So, for example, if it's a case management decision about mode of hearing, as we've been discussing, generally the judge will want to canvass the views of the parties. And so the parties can put in position statements, make their submissions, and the judge can adjudicate on that as a preliminary issue. But I suppose if the judge has already made a decision to do it fully remotely or in a hybrid format, and there's something about that you're not happy about, then I suppose you'd have to appeal the decision. I don't know what you think.
Yeah, I think it's basically a case management issue, isn't it? And we all know how difficult it is to appeal case management decisions, although in the REC that we've already been to, that was broadly a case management decision. It was a case management decision of one member of the bar who thought that her client was being prejudiced. So I suppose it's a balance of what the level of unfairness is. And if you can run a fairness argument in case management, you have to run quite a good fairness argument, I guess. Otherwise, the Court of Appeal will simply say, this is within the discretion of the court. So it depends on what it is and how persuasive you can be. One last question, I think. It's a more general finding of fact question. And it's when findings have been made, to what extent are they capable of an application to review if fresh evidence becomes, if fresh evidence arrives, if you think the original findings are unsafe. There's pretty tried and tested authorities on that. Charmaine reminded me I was in one of them. I didn't realize I was in, I did know I was in it, but I've quite forgotten about it. That is a 3-stage test. Peter Jackson, in a case called Re-E 2019, says better to go back to the tribunal if it's the same judge, if you're able to do that to the same judge, even if it's some years later, unless the judge is specifically criticized. So go back to your original court, go back to your original judge if they still exist, if they're still there. And then there's a pretty set 3-stage test. It comes from a case called Re-A-D-A-M, which I was in 2016 in front of Stephen Cobb, Mr. Justice Cobb. And it's a 3-stage test. The first being, will we allow this matter to be reopened? And that's a balance between the interest of finality, fairness, and actually the most important bit is, will there be a material change in the decision if we allow the reopening? And that's your first stage. And if that is balanced to be a reason to reopen, then there'll be a second stage is, well, how far shall we reopen? What's the extent of the investigation we should undertake to allow this rehearing? We're not just going to have the whole thing again. Should it be this component part or that component part or all of it? And then it's the hearing. So you can go to the Court of Appeal, although Peter Jackson gives us, Lord Justice Jackson gives us this way out. You don't have to go to the Court of Appeal. You go back to your original tribunal if you can, and then Mr. Justice Cobb gives us the test. So I think that's broadly the way, Norman, that you would do it if you want to do that. Have we got one last question? Have we got time? We've got 1 more minute. I'm going to hand this over to Charmaine when I've read it out. How do you deal with a judge who seems to be, I think that's making light of your client's DV allegations and is outwardly spoken about it? Oh, I think I know which judge you might be talking about there. My answer, Charmaine, would be with remarkable diplomacy, and to make a careful note of everything he says so that you can appeal it if you want to. What about any other thoughts apart from those two?
Yes, you're quite right about that. I think also just sort of politely referring to some of the recent decisions about domestic abuse, such as Re-HN, for example, just to kind of give the judge a little nudge that these allegations are not to be taken lightly. And actually, as we've seen with the 3 successful appeals, there are consequences.
Yeah, and the Domestic Abuse Act, and how the Domestic Abuse Act has now been adopted into family procedure rules, which is easy to forget, I suppose. But thank you for all of those questions. Thank you for listening to us. It's a pleasure to be able to talk to you about things. We're always happy to talk to you independently, privately. Just get in touch with us. But thank you, Charmaine, and have a good evening, everybody.